All right, let's talk about adverse impact. So, adverse impact is a common operationalization of the concept of discrimination that the courts oftentimes will rely on. And so, what do we mean by my brain? I can't look at the word and say operationalization. There we go. Can't look at it. Just say it. Operational definition, right? So we are going to use this measure as our definition of discrimination. That's basically what we mean by that. Operational discrimination. Okay, so it's defined in the guidelines as the 80% rule. So what does that mean? So let's say that you have the group that a member is claiming was adversely impacted by the hiring practices at this particular organization. So you have to take the selection rate for that group, whatever group that person belongs to, and in this organization, how many people from that group have been selected in the past. And then you have to look at the selection rate for the group with the highest selection rate and make sure that the selection rate for the group that's claiming adverse impact is less than 80% that of the selection rate of the group with the highest selection rate. If it's less than 80%, then we say, okay, there might be adverse impact where, so what do we mean by rate, by the way? Selection rate. So so let's say that you belong to a group that makes up 4% of the local population, right? So you would, and then let's say that the group with the highest selection rate makes up, let's say 60% of the population. You're not saying that a person who makes up 4% of the population should make up 80% of this organization's workforce. What you're saying is that given that they are 4% of the population and given that they're 60% of the population, what is the selection rate? Is it at least 80%? Are you hiring at the rate that you would expect given the rate in the population? I think I need to say rate a couple more times to make that really clear. So it basically takes the proportions of the population into consideration. Even if you can provide evidence of adverse impact, if you can say this group is being hired at less than the 80% cutoff, it does not necessarily mean that this is illegal discrimination. I always like to use the NFL as a good example of that, because why aren't women suing? Because they aren't being hired at the rate that they should be, right? Like half the NFL should be female, obviously. Just because there's adverse impact does not mean by definition that it's illegal discrimination. It's discrimination. They want people of a particular size, a particular strength. They want speed. They have their criteria that they're looking for. And so if it happens to be the case that one type of person has more of that than another type of person, and we're hiring the people who have it, that doesn't necessarily make it illegal. It is discriminatory in the sense of, yeah, I'm noticing that some people have the qualities we want, some people don't. And yes, there is a pattern to it, right? So that there is adverse impact to one group that's out of alignment to what's happening to the other group, but that doesn't make it necessarily illegal. All right, so let's say that you believe that there has been adverse impact in a hiring decision. What do you have to go through to pursue a discrimination case against the organization? Well, first off, you have to demonstrate what we call a prima facie case. What that means is that the numbers indicate adverse impact. Since I started teaching this class, AI has taken on a new meaning, so I had to define what adverse impact means, because you might think it means artificial intelligence if I just say AI. So the numbers indicate adverse impact. So we've established that the group is being hired at less than 80% of the most commonly hired group. Now, next step is that the organization is given an opportunity to argue against the statistics that the employee has provided. Maybe the employee doesn't understand the full spectrum of what's going into the hiring and how many people have been hired out of different groups. Maybe they just don't know all the information. And so the organization could show that, the employee is only looking at partial data, or that the employee is interpreting it incorrectly, or that they're looking at the wrong data altogether and that they needed to look at these numbers and not those numbers to make this calculation. So the organization gets an opportunity to argue back based strictly on the numbers. If the organization's arguments sometimes the organization doesn't argue back. Sometimes they go, yeah, you're right, those numbers are correct. Sometimes they argue back and the court decides, yeah, you're dancing and that doesn't make sense. And so the court rules that adverse impact exists. So one way or another, we've established that, yeah, the numbers that the employee provided are correct. The organization may use business necessity as their defense, which means they can show that they use a selection battery that is job related, and all minority and majority groups, everybody who applies takes the same battery. And now the burden of proof shifts back to the employee to show that the organization has a biased battery, that, yeah, while it's true that you're applying it to everyone, this battery is designed to make sure that you're picking some kinds of people while not picking other kinds of people. I mean, I think the NFL would make the argument that they use the battery of like high school performance, college performance, maybe the combines that they have to, let college players play. And this is our selection battery, and that anybody who wants to compete in this selection battery is welcome to do it. And, we're not discriminating. This is just who's in front of us. And so I think that's why they've been immune to like a sexism case, right? Because the battery that they use, anybody's welcome to participate. I don't know. I think there'd be a lot of harassment if a female wanted to actually get into the combines and stuff. I have a feeling it would not be a friendly work environment, but I'm not sure. I'm just saying that. I'm just talking and I don't have any evidence. So it goes back to the employee though, to prove that this selection battery is designed to be biased. And this is where it can be a really big benefit for an organization to employ an IO psychologist for a couple of reasons. One is because they have the skills and the knowledge and like that to pull in the best measures to get at the skills and things that the organization says that they want. Second off, the IO psychologist is not invested in this organization the way that people who are in the organization are. And so the IO psychologist is much more likely to be trying to hire the best person and much less likely to want to help a discriminatory organization because they're not part of it. Like there are ethics that would suggest that the IO psychologist should report any evidence of overt discriminatory practices and things like that. And so if you are an up and up organization and you're trying to follow the best hiring practices, it's in your best interest to have an objective person involved in the process. That's all I can say on that. A lot of organizations have affirmative action plans in place where their intention is to increase the number of minority or protected class members in their organization. And their goal is to recognize that historically there have been maybe processes in place or individuals in place who have eliminated out of the running qualified applicants who were not able to get their foot in the door because of this gatekeeper or the process that they had been using. And so they're trying to redress historical problems, not trying to say we need X number of people from this group and that group. These can be really controversial. A lot of people object really strenuously to the idea of ever saying that we need to have X number of people or this percent of people of this type in an organization. Research in this area has mostly focused in on studying the stigmatization that follows affirmative action in an organization. A lot of times when a person is brought into an organization that historically has not had very many people of that type, they will experience stigma because the incumbents who have been working in a certain scenario will say you were just brought in as an affirmative action hire and you don't really have the skills. If it weren't for whatever category you belong to, you wouldn't have been hired. Like, they will really give people a hard time about that kind of thing and make them feel less than. Also, perceptions of justice has been a focus of IO psychologists who have been studying affirmative action plans. And then they study just the plans themselves. Like, what is in these plans? Are they really going to achieve the goals as stated by the organization? That kind of thing. Like, are they working the way that you want them to work? So IO psychologists have been looking at affirmative action plans from a couple of different angles for the past 40 years, 50 years maybe now. I thought I'd share a few Supreme Court decisions relating affirmative action plans. The first ones have to do with education. So, and education has been sort of a model for what is going to go down on other sort of governmental lines. So Gratz versus Bollinger in 2003 at the University of Michigan, they were awarding global points to people based on their racial groups. And they were ignoring individual differences, they were ignoring qualifications, and that was ruled against. You can't do that. Grutter versus Bollinger, again at Michigan, but this one is the law school. And in this one, they were allowed to continue to consider race in their applicants because the argument from the court was that diversity is a compelling interest for a law school. But you have to consider elements of diversity on an individual basis, which is one thing that they were doing wrong at the just general University of Michigan, is that they were not taking individual differences into account. They weren't taking individual qualifications into account. They were just, if you came from a particular racial group, you just got extra points on your application just off the top. And so that was found to be unconstitutional. You can't let race be the defining feature of the decision according to the Supreme Court in Grutter versus Bollinger, but you could use it as one of the factors to try and boost diversity in the law school. However, the Students for Fair Admission versus Harvard and also versus the University of North Carolina in 2023. So this was one case that got wrapped up together. It was two cases that got wrapped up together in one Supreme Court case, and was ruled in 2023 that accounting for race at various stages in the application process violates the Equal Protection Clause of the 14th Amendment of the United States Constitution. And so no longer can any school, for any reason, use race in their decision making. So these earlier Michigan decisions, particularly the law school decision, have been overturned by the more recent 2023 finding. Now, in the world of work, the Chicago Police Department was sued by a plaintiff with the last name of Pettit. And Pettit was arguing that that the police department was making decisions based on race, and it was upheld. That there's a compelling need for diversity in a large metropolitan police force to protect a racially diverse and divided population was part of the findings by the Supreme Court. And so in hiring decisions for employees, it was okay, according to the Supreme Court, to make these decisions in part based on like the racial makeup of the neighborhood. Ricci versus DiStefano in 2009 sued the New Haven Fire Department because the examination scores of white and Hispanic candidates for promotion were discarded. They were literally just thrown away because not enough candidates from other racial groups passed the tests. And so they said, no one's getting promoted, everybody's like, it's all being discarded. The court decided that the plaintiffs had rights violated under Title VII of the Civil Rights Act of 1964 and the 14th Amendment. And so the New Haven Fire Department was found to have violated the civil rights of white and Hispanic applicants when they said no one can be promoted because we didn't have a diverse enough group. Something to keep in mind is that the Equal Protection Clause does not apply to private employers. And so you'll notice that these are universities, these are for student decisions, these are governmental agencies like the police department, the fire department, the military, other places. They have equal protections that they have to fulfill. That clause does not apply to private employers. And so it gets a little bit more murky if you're working for a private employer, a charity, what would you call it, an NGO, something like that. All right. Let's go ahead and take a break here, and we'll come back and talk about affirmative action in the workplace in the next video.